there's a fatality as a result.
Yes, sir.
Can you please read to me what happened?
Right away, we're talking about a fatal crash. This instantly escalates the case to potential felony-level charges. But the real legal fight is causation. Did she actually cause the death? Or is this going to become a technical courtroom?
Yes, sir. This crash happened back on December 24th of last year. Officers were advised of a four-vehicle crash at 5:37 a.m. on the 6300 block of I-45 South here in Harris County. Investigators observed massive damage on a Chrysler, indicating a head-on impact, massive force damage on a Mitsubishi, indicating a T-bone impact to the driver's side. Officers spoke with a HFD firefighter who was on his way to work and observed the Chrysler strike the Mitsubishi. The Chrysler cut in front of him, causing him to swerve to the right and hit an Amazon truck. He states that this defendant was the driver and sole occupant of the Chrysler, and the driver affirms the wheel witness's story and stated that he clipped the Chrysler as he was coming to a stop. The complainant was taken to the hospital where she was pronounced deceased. Officers observed an unopened beer can in the driver's seat of the Chrysler. This defendant stated that she was the driver and that she struck the vehicle. They observed a strong odor of alcohol on her breath, red glassy eyes, and slurred speech. She was transported to the hospital, and a DRE arrived, and she was Mirandized and she waived her rights. She stated that an SUV was stopped in a lane and she tried to swerve to avoid hitting it and then crashed into the other vehicle. She admitted to consuming 4 to 5 12-ounce twisted teas and smoking marijuana.
And alcohol in the car while she's driving?
Yes, sir. SFSTs were done. She scored 6 out of 6 on the HGN. She did not have vertical gaze.
Now this is serious cocaine, THC, alcohol all in the system. Legally, this is strong impairment evidence, but defense will still argue accident mechanics. Do you think multiple substances should automatically equal full criminal life?
And officers observed a lack of convergence. They were not able to do the walk and turn and one leg stand due to her injuries of a broken arm and sternum. There was a blood warrant and residual search warrant that were done, and her blood, Your Honor, came back at a 0.025 for ethanol, and she had... Yes, 0.25, yes, sir. And then she had marijuana and cocaine in her system.
And what's wrong with that?
We worked out an 18-month probation offer with 7 days as a condition, Your Honor.
That's not the fact that there's a dead body in this case. Why is it not an intoxication?
It's a causation issue, Judge. We looked at it for an upgrade, is my understanding, because the other vehicle was on the roadway. Legally speaking, there's a causation problem, Judge, so that's why we came to the agreement that we have the families on board.
I'm not sorry, I'm not going to take the You have a dead body here. She has cocaine in the system. She's got foods in the car while she's driving, and a dead body. I'm not down with that. No, we're going to have to do something else, but I would be remiss a week in jail where we have a dead body.
Yes, sir.
Here the judge completely shifts tone: frustration, emotion, and moral outrage over a fatality. But legally, they're still stuck with causation issues. Should justice follow strict legal limits, or the emotional weight of a lost life?
And to me, just because you're 9 months pregnant doesn't factor anywhere in my mind, Ms. Sanchez. Ma'am, look at me. While you're about to give life, you took someone else's life. I'm sorry. How many lives are now ruined because of this? Not only yours, how about everybody else? Every single day in Harris County, someone is maimed because of the DWI. It's sick that we lead the nation in fatalities. And I don't know why they can't prove causation to charge you with intoxication manslaughter. But to me, a week is insufficient. It's not enough.
Okay. Yes, sir.
So
we'll go back to the drawing board and get
back,
it.
but
yes, sir.
I'm ready to set this case for trial now. So unless we can work something out today, I'm saying it gets set today.
Yes, sir.
Okay.
All right. Thank you, Judge.
Your Honor, I understand that a fatality did occur, but the reason why they weren't able to charge my client with intox manslaughter is because this accident was unavoidable. If you're
unavoidable?
Yes, sir. At the time of this accident, it was unavoidable. What ended up happening is that the deceased party spun out in front of her, and she was just going straight. The only thing that she did wrong at the day and time was drive a vehicle.
With cocaine, alcohol in her system, beer in the car at a .20. Let me ask you something. Have you ever done breath test? Have you ever blown into a breath test machine? Have you ever done those wet labs? You ever done that?
Okay.
I'm serious, really.
Okay.
Have you ever done it?
I'll go one further, Your Honor. Before being a defense attorney, I was a lieutenant with HPD.
Okay.
So I'm above and beyond. I spent 3 years doing accident division. So not only did I investigated these. So my knowledge is probably more superior than anybody in the room. I spent 3 years picking up dead bodies. And that is a true and factual statement I'm making before the court. So yes, sir, I have.
I did, as part of training when I was a defense lawyer, I went to these classes where we took the breath test machines apart, did all kinds of experiments, did these drinking wet labs where you drink and then you blow into the machine. And the one time we did it, we downed a bunch of booze and I blew into the machine and I was lit, right? And I blew a 14 and I was lit, man. And all I did was I blew a 14, right? 0.14. She's at a 0.2.
0.025, Judge. 0.025.
0.02.
Yes, sir.
Okay. I thought you said 0.20.
No, sir. No, it's 0.025 with the cocaine and THC.
No, so she's not 3 times or 4 times over the legal limit, yeah.
We were discussing about Ms. Sanchez. We were discussing when for you to do jail time. Should we have you do it immediately to where you have the baby in jail? Is that cruel and unusual punishment? But then again, is a dead body cruel and unusual punishment? You know, what's fair? What's not fair? I don't know. All I know is that you're charged with DWI. There's a dead body, but they just can't prove causation, and that's why you're not charged with manslaughter. But the fact remains is that we have a dead body. How do we reconcile that? You know, you're pregnant now, and I truly hope that you've treated your body well throughout that pregnancy. Because if you haven't, and you've used anything while you're on probation, you're guaranteeing yourself a life of babysitting of a potential baby that will have developmental, potential psychological, physiological issues that you'll have to babysit for the rest of your life, which is punishment in and of itself. It's not fun. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you guys have worked out is 30 days in jail as a condition to probation for 18 months. As part of the probation, does she have any prior DWI staff?
No, Judge.
Any other criminal history?
Juvenile history only, Your Honor, but nothing DWI.
What all were you wanting done on the probation? Correct.
Yes, sir. We are asking for DWI education class, a victim impact panel, guardian interlock, no refusal, no drugs or alcohol, random UAs, 80 hours of community service, and a $300 donation to MAP.
Is this how you understand the conditions, Ms. Sanchez? I will keep you to it strictly. I'm going to monitor you myself. You will report to me here to the court so that I make sure everything gets done well. If you are not in compliance, I will issue a warrant for your arrest. You will be put into jail, and then you'll be facing up to 180 days in jail. If you test positive for alcohol or any kind of drugs, I will put you in a treatment facility in the jail. Do you understand, ma'am? No alcohol, no dope, no driving. You must have what does she have now? Does she have a scram right now? Do we know if she's had any violations while she's been on? I don't think so,
I
right?
haven't
She hasn't
seen
any
any, Judge, no.
Okay.
She has a scram device at this time, Your Honor.
We're gonna have to figure out something about, as far as the baby situation with the interlock or with the portable device. I will follow the state's agreement here. But like I said, I'm keeping you close to me. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, if possible immigration consequence, you can be deported, excluded from the country, denied naturalization under federal law. Hey, if you can do the repeat offender, do you get the education class? Did you say victim impact panel?
Yes, sir.
How many?
One.
One victim impact panel. You will be required to do a TRAS, which is an evaluation to see what other conditions you may need. You must fulfill those conditions. Guardian interlock, no drugs, alcohol, random UA. When are you set to deliver, ma'am? What day?
August 20th.
When do you think we should do the time?
If I could request anything, Your Honor, it'd be the beginning of the year, in January 2025, the start of the year. That gives her time to nurse her baby and everything else.
She must get it done within 6 months. Okay. All right, ma'am, how do you plead to the offense? Guilty or not guilty? I will find you guilty. We'll send you to this agreement. Good luck to you, ma'am. 6 months in jail and our $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
July 18, 2024, officers were dispatched to an apartment complex in Harris County, Texas. Upon arrival, the officers met with the complainant, who stated that he was being followed by the defendant, who was masturbating in front of the complainant on multiple occasions. The complainant stated that on June 6, 2024, he was painting an apartment in a public area of the complex when the defendant showed up and began masturbating in front of him. Complainant has video footage of the incident and showed officers where the defendant is seen standing roughly 20 feet away from the complainant with his shirt lifted and the front of his shorts down, rapidly stroking his penis.
You said this is an apartment complex.
Yes.
What apartment complex is this?
1 second, Judge.
Mr. Martin, I'm going to find that there's probable cause to go forward with you. I'm ordering you now as a condition of your bond to keep it in your pants while you're outside. Do you understand?
Yes, sir.
If I find that you pick up any more cases like this, you start acting like this, I will put you in jail. No more PR bonds for you. Do you live at this apartment complex? I don't know what we're going to do because I don't want you to go within 200 feet of this person. I don't know how we're going to handle this now because I don't want him going anywhere near this person. Is this a maintenance worker or who is it?
I believe so, because it says he's painting a public area in the apartment complex.
Can you do me a favor? Would you mind guys reaching out to the apartment complex, perhaps the manager, finding out who this person is, how we can keep them away, where Mr. Martin lives in relation to everything so that they don't accidentally bump into each other. Mr. Martin, I'm telling you now, if I find that you start acting a fool again like this or doing anything like this in the public, you know what happens. You got out of jail because we gave you a PR bond. What's going to happen if I raise it up to 10, 15,000? If you don't have anyone to pony up that kind of money, you'll be stuck like Chuck in there until this thing is over with. Do you understand?
Yes, sir.
Okay. For now, I want him to just take a seat in the jury box while we figure out about the apartment complex. I'm going to have you sign up. Hold on. How old are you?
I'm sorry.
What do you do for a living?
I'm gonna start start working soon for valet in the downtown.
Did you graduate from high school?
I'm sorry.
Did you graduate from high school?
Yes, sir.
What did you do after high school?
After high school, I went to college for a couple years. Then I had dropped out due to personal problems, and I just started working ever since.
What happened with, as far as personal problems?
Just
Why stop? I mean, you're headed in a good direction. Why stop?
well, in the midst of personal problems of me and my family was on the brink of homelessness sometimes, and I had to drop out of college to basically get a job or another job to basically help pay bills within our household. So,
When is the last time you've had a full-time job?
about 3 weeks ago,
Doing what?
I was working at Popeyes as a cashier.
Okay. Who do you live with now?
I live with family currently. I'm sorry.
Who? Mom, dad?
Mom.
Do they know about this case?
They some information, but not the full details.
Be careful, because I will give you a lawyer today, Mr. Martin, but you know, if you start acting up and I put you in jail, everyone's gonna know about it real quick. And then things are just gonna go sideways. You have the opportunity now. We gave you a free bond. You're out there now in the free world. Don't act up in the free world, otherwise I'll take it away from you. Do you understand?
Yes, sir.
I don't want you to trail anyone, not only this person, but anyone. Do you understand?
Yes, sir.
Okay. I'll have you go to Victoria Sign and Reset. In the interim, I'm going to have you fill out an application for an appointed lawyer, and then I want to find out from them more information, and then we'll revisit this. Okay?
Yes, sir.
It's an indecent exposure where he's out and about. He's out and about following people allegedly and going at it.
Okay.
My concern is that he lives in an apartment complex where this was allegedly happening.
Yes, sir.
So I want to craft conditions that he doesn't go anywhere near the complaining witness. And if this person is a regular worker at the complex, we might have an issue. I don't know.
He is an employee. So he works there. Every time I spoke to him, he said like that was my work site at the time. Does he work there?
So I tried reaching out to him. I called several times. He not pick up. I left voicemail. I tried to contact the apartment complex. It does not transfer to a real person. It says go contact on our website. So I filled out the contact form, and yeah. So
Get it?
so if the complainant is just an employee who works in the apartment complex.
Problem is those guys, they're floating all over the apartment complex, and I don't want him to run in. I don't want you to have contact with this person, right? I don't want you to actually bump into him. You're making it as awkward as it can be. And I don't want you to make it any more awkward for this person who all he's trying to do is work and earn a living.
Yes, sir.
So I don't know how we do this, Carl, because I don't want him to have contact with this person, yet the person works all over the complex. He's the maintenance man.
Right.
I think a no contact order would actually suffice in this one because the complainant's been pretty responsive to me.
Okay, but-
I think no contact
No
order.
contact, but he can still be across the way, still doing what he's doing.
If he's
No.
if he's continuing to do what he's allegedly doing, he would pick up a new law violation. I mean, that's already been established by the fact that we've arrested him already for that. So, I think
No.
admonishment and no contact. The complainant would tell me.
Because I mean, if you think about it now, though, he's not been contacting him, right? He just goes near him and does what he's doing.
Well,
What I want to
actually, so
do is I don't want him to even go near this person.
The complainant hasn't seen him since, so that's actually, from what I understand, but I contacted him just yesterday about this case. Actually, I contacted him. No, the case notes. 2 days ago, sorry. I contacted him 2 days ago. There hasn't been any subsequent contact.
Okay.
So,
Do you mind just one more time letting him know we've entered in a no contact order and I don't want him to go anywhere near this individual. I don't want you to go near him at all. If he's working at a particular location, you happen to see him, go the other way, walk the other way. You go near him, I'm going to put you in jail. That's it. You know, if your family is truly having problems with money now, do you think that they're going to want to pony up $5,000 to $10,000 to get you out? No. So that's, you know what's going to happen. Because if I see it again, your bond will be $10,000 to $15,000. That's it. We mean business. You understand?
No contact without the address exclusion.
Okay, so Mr. Martin, no contact, no weapons, and just don't go near him. I mean, I guess 10 feet, but does it give a distance of what the normal interaction now was? Was it like 10 feet, 10 feet?
It doesn't give it. No, it doesn't give a distance, but I'm not aware. I don't think the complaint.
You're smart enough to know, just don't. Okay, I guess that'll suffice, Carl, and we'll see. I've given you a lawyer. It's your responsibility to stay in touch with Carl. He will help you with this case, you know. The other thing that you need to understand is these types of cases, if you pick up a second one, you have to register as a sex offender. And you register as a sex offender for a minimum of 10 years. And I'm going to tell you, once you get on that registry, your life is basically over. Everyone knows about it. You can't do anything in your life without being monitored by everyone. The federal government, local law enforcement, district attorneys across the state. Really. So, take it to heart. Okay, guys. Thanks.
Thank you.
Is that a state's bond condition?
Yes, state. Mr. James Basie, where did you think that you were coming today? To the beach? You have from 2008 a prior interference, 2014 assault of a family member, in 19 an assault impeding breath with a choking case, in 2015 a theft, 2017 a theft. Now, I don't even know what's he charged? So what you're charged with impersonating a private investigator. On September 13th, 2024, did then and there unlawfully impersonate a private investigator by intentionally and knowingly purporting to act as a security guard for a bar establishment and conduct pat-downs of persons entering the establishment and requesting identifications by persons entering the establishment. This is a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Mr. Bassey, next time you come here in court in shorts, I'm going to send you right back out and we'll reset your case the next day. Do you understand? It's a complete lack of respect. And you've had now, this is your 1, 2, 3, 4, 5, your 6th case. You know better. Okay.
On September 13, 2024, a law enforcement officer conducted an investigation at 2709 Airline Drive in Harris County, Texas. This location is a known bar/club. The investigation was conducted in an undercover capacity, and the detectives were dressed in plain clothes and driving unmarked police vehicles. Prior to this investigation, the detectives received a tip that the bar was operating illegally by selling alcohol during prohibited hours and also had minors inside working and consuming alcohol. Prior to the investigation, the law enforcement officers discovered that the bar was operating under an alcohol license. Upon entering the bar, the law enforcement officers were stopped at the door by the defendant. The defendant was wearing a security shirt. The defendant told the officers to empty out their pockets and conducted a pat-down search. While inside of the location, the officers observed the defendant conducting a search of all patrons that were entering the location and would close the front entrance after every patron entered. The officers also observed the defendant periodically check in with the bartender from time to time, a task that a security officer performs at liquor establishments and not a normal patron would be allowed to do. The officer did not observe any underage minors at the location. Upon making contact with the defendant again, he advised that he had a security license. but he did not have an active security officer license, nor has it been documented as having a license in the past.
Sir, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you as a condition of your bond not to engage in this type of behavior. You're not to act as a security guard or do anything of this nature. If you do, I will revoke your bond, put you in jail. You will not get any more PR bonds. Do you understand? We are going to reset your case to give you time to hire lawyers. So I'm first going to have you go to Victoria, sign a reset. After that, we'll have you take a seat in the jury box while they get your bond conditions. We'll have you sign it. And after that, you'll be free to go. When you come back, don't come back in shorts.